Welcome to Ground Rules, the show where we uncover the unwritten rules of real estate through the lived experiences of the people who build, shape, and fight for the industry every day. I'm David Shamshovich, co-head of BBG's Tax Exemptions and Zoning Incentives Group, or TESI, as we like to call it. And for our very first episode of Ground Rules, we're starting from the ground up with Jeff Goldman and Dan Altman, the co-managing partners of Belkin Burden Goldman. For those of you who don't know, BBG was founded in 1989 to fill a gap in New York's real estate legal market. Elite owner-side representation across litigation, transactions, and regulatory work. 35 years later, the firm has grown to 60-plus attorneys. It's ranked by Chambers as one of New York's top real estate firms and is led by these two. Jeff Goldman is a founding partner and one of the city's most experienced courtroom lawyers. But his real expertise is in the unwritten rules of high-stakes disputes. Over 35 years, he's navigated co-tenancy battles in major retail centers, rent regulation warfare, and the chaos of COVID-era commercial litigation. He'll tell you the law is just the starting point. The real game is knowing how to settle, when to fight, and how to read the room. Dan Altman built BBG's national transactional practice from the ground up, closing deals for global brands, major landlords, and everyone in between. His portfolio includes 20-year supermarket leases, Empire State Building office transactions, and multi-state retail rollouts. But he'll also tell you every deal has a breaking point, and the trick is knowing which terms actually matter and how to structure agreements that won't blow up years later. Together, Jeff and Dan embody the deals and disputes that shape the industry. And with that, let's get right into the unwritten rules of real estate. And my first thing that I'm going to say is welcome, Dan and Jeff. And to me, this is a really exciting moment because it's a new chapter. It's for the firm as well. This is the first podcast of the firm, and we're really excited to get this going. And this is the episode that's really going to start the whole thing. This is the big bang that really creates the impact. And I appreciate you guys taking the time out of your busy schedules. You're managing the firm. You're head of the major groups in the firm, and you're sitting down and taking the time, and I want to say that I appreciate that very much.
Thank you.
Thank you, David.
So Jeff, why did you go to law school?
I guess the reason I went to law school is I really had no idea what I wanted to do. A poli-sci and psychology major wasn't going to get me to where I thought I wanted to be, and I loved to argue. And I thought law school would be a good place to pursue arguing. I was always very competitive. I hate to lose. And arguing to win was something I thought I would enjoy, and I do.
And so was it, when you did go to law school eventually, what was it that really still continued that trajectory? You know, some people go into litigation, and we'll get to that in a moment, and they decide, like myself as well, by the way, who practiced it in 8 years, and decide, you know what, I love to argue and win, but I don't want to argue and win like this. So what kept you on that path?
I think the challenge. I was always somebody who doesn't give up in a challenge. And a funny story, in law school, we were doing moot court, and it was my first stand-up argument before judges that they brought in at Buffalo Law School. And I don't know if the audience has ever seen the movie Airplane, but there's a scene where the pilot is navigating the plane and the water is just pouring down, literally. And that was me in my first oral argument. And notwithstanding that, I just love the excitement of arguing and winning where I can. But thinking on your feet, engaging the brain to address things that come up, I loved it and still do.
Yeah, no, I completely understand that feeling. At the same time, a lot of it's not just arguing, right? A lot of it is letter writing. I guess it's persuasion. A lot of it is talking clients off of the ledge, right? Acting like a psychologist. So there's a lot of things that don't involve the arguing as well, which may not be as exciting to some. How do those things kind of work within the realm of the things that you like to do?
Well, I think, to your point, how we grew the firm from 4 or 5 people to over 60 now, keeping the focus on the client. What does the client want? What does the client need? What does the client need to hear to make the decisions that they need to make to get the result that they want? I tend to be brutally frank. I'm very sincere and honest with clients.
I haven't noticed that.
No, you probably haven't. I think everybody here at the firm knows that. And I think it's important because I think clients need to hear the truth, the good and the bad, and because that's the only way you can make reasoned decisions in the litigation world and in the negotiation world. It's really important. So maybe my psychology degree from Albany actually has paid off to some degree. But look, it's a challenge. Fighting with adversaries and judges is certainly a challenge, but there's nothing like winning.
Yeah, I mean, I couldn't agree more. Winning is a great feeling, although I'm sure that's juxtaposed by the losing. And so now I want to kind of just turn to Dan and be like, well, Jeff is all in. He's clearly a litigator for life, right?
Right.
But Dan, you and I both started as litigators, and we said, you know what? We kind of just want everybody to get along. Although there is enough fighting when you're negotiating, but it's not the same type of thing. No, not even close.
Not even close.
It's like a vacation.
Right.
It's a paradise compared
That's
to
how I
litigation.
see it. Dan may not see it in the throes of a negotiation.
Yeah, I mean, listen, I completely understand that, but what drew you to litigation and what kind of drew you away from it?
Well, it's funny that you asked because Jeff was one of the people that was primarily responsible for me not only coming to the firm, but also being in the litigation department when I first came here. And, you know, I kind of started a little differently. I went to law school by happenstance. I had a brother who I looked up to. I also went to Albany, and I was kind of like a lost soul. I graduated with a business administration degree and didn't know what I wanted to do after I graduated. So my brother was actually graduating law school at the time that I was deciding what I wanted to do after I graduated from college. And I asked him how he liked law school, and he said to me, you know, I really like it. I enjoy it. It's really trying on the mind. It goes ahead and challenges you in many ways that, you know, you can't believe. So I said, okay, that sounds good to me. I'm going to go to law school.
Did you do any diligence after that, or did you just rely on that piggybacking?
That was my simple analysis. That's how I decided to go to law school. So, but yeah, I started out. I went to Brooklyn, and I started out. That's where my brother was. He had graduated. I came in as a first year. I was able to get you know, all the great outlines from his friends who were still there that he gave the outlines to, so they reciprocated, and it was a fun time. I graduated. I was a summer associate at the firm that Jeff came from, and I had decided at that time, you know, let me go out and look and see what I could do. I interviewed, and it turned out that I got a job, an offer after the summer to come back. I took the bar. I got married. I ended up working, you know, full time at the firm, and I started out working in litigation. At first, I enjoyed it. I enjoyed thinking on my feet, getting up in front of judges, making oral arguments. And then as time grew on, I felt like, you know, what I was doing didn't matter as much as I could otherwise do if I was, you know, doing deals and transactions. So that was the reason why I ended up switching.
Yeah, I mean, I completely understand that. That's similar to my story, which is in litigation, you can't leave anything unsaid. If there's a letter, you certainly have to respond. You don't want to waive any right. Like you have to basically cover because you just don't know where the angle's coming from. Yes, transactionally, you're doing some coverage as well, but it's not as intense, and you're not trying to cover every single angle because you're trying to, at the end of the day, make a deal.
Yeah, the other difference is in litigation, you are at the mercy of the court system and a judge. Two variables that have tremendous impact on the length of litigation, the result of litigation. One of the benefits of what Dan does is you control the timing and the narrative, and it's just you and your client and your adversary and the client. There are no other outside influences that you have to account or adjust for like we do.
Unless you have a fight, in which case then you need somebody to mediate, arbitrate, or judge that dispute. Right. And so for me, when I'm looking at a transaction, only because of my background, I'm looking at it from a litigation perspective, particularly if it's something that's very critical. And so when I'm looking at document, I'm looking at it from a perspective, if a judge or a clerk is looking to decide something, how are they going to view it and make sure that it's clear enough? Is that something that that you do as well? Does that help you in your structuring of transactions and negotiating?
Yeah, it certainly does. I think one of the most important things to do is to really focus on the client, speak to the client, find out what the client really wants, what their needs are, and then to take that and put it into the deal. You know, a lot of clients don't want to get caught up in minutia. They don't want to get caught up in, legalese. A lot of them don't understand it, and they don't want to pay for it either. So for me, I try to be a deal maker and, pay attention to what the client wants and also the timing of the deal. That's very important and critical when it comes to satisfying clients.
Yeah. No, I fully agree.
One of the things that I think makes our firm special and unique, and Dan and I have worked closely over the decades on this, is sometimes Dan will ask me to read a clause in a lease to get my perspective, either in its drafting or it's already been drafted, and now interpretation. What do you think a court is going to do? What's going on in the legal system that would impact this language? And I think one of the things we offer as a firm is we litigate commercial leases and contracts. We know the issues and the problems, and we can very easily navigate that to their department and say, look, this conditional limitation clause, or you have a comma here, a court may interpret that as a pause and not being inclusive versus exclusive. So we work together in trying to make sure that contracts and leases, are not that they're ever litigation proof, but they are as litigation tight as possible.
Yeah.
And to that point, many clients ask us to revamp their leases given that experience. Yeah. It's invaluable. I mean, there are not many firms, if any, in the city that are doing both, are experiencing the decisions of judges, taking those decisions, redrafting a lease clause practically so that the client says, wow, this is really something I never thought of. Thank you for that guidance. And that's the expertise that we offer, to many of the real estate owners in the city.
Yeah, I think it's invaluable because having that cross-discipline and across transactional litigation and beyond as well, including regulatory things, administrative law, those are invaluable. But the focus obviously in BBG is real estate. And both of you are focused on real estate, both transactions and litigation. And this is a question for both of you, I guess. What drew you to real estate, or was it, again, happenstance? This is just kind of like how I ended up, and that's a fine answer, but what is it that's different about this transactional or litigation from real estate related disputes versus others, if any? And so that's kind of the question, is like, why is it real estate, and what is it that differentiates that from kind of general transaction or general real estate?
For me, when I graduated law school, my first job was working at a defense negligence firm. Got great experience. After 6 months, I answered an ad in the paper, and it was a real estate law firm. And so I didn't want to do defense negligence anymore, and I just started working.
I wonder why.
Yeah, and I just.
It sounds so much fun.
And it's funny. My dear friend, childhood friend, still is, did personal injury. So there was really the yin and yang on that perspective. But I started at a firm just because that was the next phase in my life. And I did that. I enjoyed it. And then people were leaving, invited me to start our firm. And that's how we started the firm. And I love real estate.
And there was never a question about, we're going to expand beyond. Yes, we could do all litigation. Why not just do contracts? Why not do other things?
Well, we do litigate contracts. I don't want to, where the contracts pertain typically to real estate, whether it's partnership agreements, contracts, etc. But I rather be an expert in something than to be a generalist across the field. And I think we started the firm, and our firm is an expert in what we do. It doesn't pay to generalize beyond that.
Yeah, and I use the phrase "stick to the knitting." A lot of people in the transactional department know me for that phrase. And it's really, focusing on the things that you really do well. And there are certainly things that we could have taken on over the years, but we've grown this practice by doing the things we know how to do really well and growing from there. Whether it be, commercial litigation, transactional law. We're not a trust and estates focused firm. We're not a corporate firm. We don't do mergers and acquisitions. We stick to what we know how to do it really well, and that's how we've grown the firm.
Yeah.
And people appreciate that because, honesty is a good policy. If you don't know how to do something or you don't feel comfortable doing it, you tell the client, and many of them appreciate that.
Yeah, you and I had that same conversation about it, and there are lots of new lines of business, particularly now with the regulatory environment being what it is.
Right.
Which is within our wheelhouse, for example, my groups or someone else's, but it's new. And so we have to learn it and start it, and that's okay because we've had that past experience. But getting into something completely new with that experience is difficult, and the way that you brand the firm, which is, this is the real estate firm. This is what we do.
But there's a difference. I just want to make clear the difference because, it's one thing to be a real estate firm and then to take on a zoning practice, which is complementary.
Yeah.
Also a tax incentive practice, which is complementary. We've done all of those things very methodically and deliberately, and that's worked well for us. So that's a lot different than, being a real estate law firm and then becoming a trust and estates firm or taking on, mergers and acquisitions.
Yeah. I think that's a great point.
Yeah.
I wanted to follow up on that because I think that's an interesting point, which is you started out with this core, and obviously you're not thinking too much, right? You're just going about doing what you need to do. But then you are expanding into, I wouldn't say tangential, they're all real estate, but it's zoning and land use is very different, right? Regulatory, admin, dealing with DOF, DOB, HPD, all those agencies. Mm-hmm. That's related but tangential. Your clients will want those things because they're owners and landlords. How did that decision get made? Did you stabilize yourselves first, feel like we're on good footing, we're doing well, now we want to expand, and then how does that expansion start?
Well, I think historically we try to get our feet under ourselves in the beginning. I mean, we were 4, then 6, then 10, then 12, then 15. And when you are rapidly expanding just in personnel, doing what you do, what was most important back in the 90s was being able to pivot depending upon what the economic environment was in the city. There was the crisis in 2008 and foreclosures, so we organically transitioned to doing more foreclosure work. Banks were taking back properties. We then began to represent banks because they didn't know how to take those properties. Then our first real big growth was expanding into co-op and condo work. And Aaron Shmulewitz joined us with 2 or 3 other people. And we, assimilated them into practice, and we grew and grew and grew. We, grew the transactional department, and then once we saw how to do it, like to Dan's point, get people in, get them acclimated, get them introduced to the clients. When you build it up, then it's time to expand. We do a lot of 881 work now. We weren't doing any of that 10 years ago.
Right.
Now Dan's department has 3 or 4 people. Pretty much is all they do is that work. Takes good management. It takes training and supervision that we provide, not just Dan and I, but the other equity and non-equity partners in the firm, give the necessary guidance and supervision, and we build it from there.
Yeah. I don't think it was ever a deliberate decision where Jeff and I actually sat down and said, you know what, let's grow the firm. I think, you coming on is a good example. You knew somebody here at the firm.
Yeah.
At the time, we had been trading referrals back and forth for many years. It was a natural extension of what we did. And that was something that we saw, we liked, and we took on. We hear our clients, a lot of our clients, like with Ron Mandel, who heads up our zoning practice. A lot of clients, they wanted advice on zoning, land use, opinions. They wanted all that. And that's why we reached out to Ron to bring him over here. And we've grown to basically where we're a one-stop shop. We could buy the property for the client, we can advise them on tax incentive work, we can advise them on whether or not they can build a 15-story building or a 30-story building.
Yeah.
We could help them lease up the property. We could help them manage the property. We could do construction-related agreements. We could do all those things that clients really appreciate and look to us, for that kind of work.
Yeah, I think it's important because this way you keep everything in house and you can just work internally, and I think that makes a lot of sense because the way that myself and Jason, my partner, that came over with tax exemptions and zoning incentives, we work very closely together because those programs work in tandem. But now we're working with the admin group a lot because they're doing DHCR registrations, they're doing rent. So like all these three components are kind of like working together, and it's so much easier because A, it frees us up to do other things, and we're not necessarily experts, and so we can't do it all. And we have somebody to rely on, so it creates a more platform, and we can take on more matters. So listen, we're extremely pleased to be here. We're very happy with the platform, and we're hoping that it'll grow more. I'm sure the needs will arise.
Yeah, go ahead.
I was going to say that's evident by the clientele that we both share, and we shared before, and now we share now. And the clients are happier now that they can come to us and say, "Hey, David, we have a ground lease question. Can you get someone involved who can answer a ground lease question? You can walk down the hall, and speak with me about that." So that's really special. It's exciting, and it's what's driving our practice now.
Yeah, I was just going to add, I just take it one step before that we could represent somebody who wants to buy a building. We have an incredibly large portion of our practice doing due diligence to see whether or not one should consider buying it, and if you are, is the price right, or should there be a reduction because the diligence reveals problems? We often are representing clients who didn't hire us for the due diligence. They buy the building and they come to us after they are now the owners, and they realize the problems that the building has that had they known, they never would have paid what they paid for it. So I don't think there's any firm in the city that has the kind of due diligence work before one is willing to even sign a PSA. So we have clients who hire us for the due diligence, negotiate the PSA, we do the closing, then we just follow what Dan said: manage, lease,
operate,
take refinance on the property. We do all of that.
Yeah, so I found, and in my opinion, having that stuff all in-house under one roof and having that kind of one-stop shop mentality and ability, of course, is key. But I found that some clients, not all, some clients, they really compartmentalize. This is my loan guy. This is my PSA guy. And that's how they'll deal with it. And they're loyal to a T, and it doesn't really matter unless the other guy really screws up. Are you able to kind of overcome those types? I'm not talking about the clients, which I think it makes more sense, right? You're getting a better deal if you're doing everything in-house.
Yeah.
How do you approach, and this is for the both of you, how do you approach someone where you're pitching something like that and they say, "No, I got my loan guy, I'm loyal to him, and I got my zoning guy," and we say, "Well, we have all these people and they're amazing, why don't you use us?" "I've been using this guy for 10, 15 years. I want to stay with him."
Yeah, I've been trying to change that narrative for 35 years. Not taking anything away from our litigation department, which is best in class. We're known throughout the city for our, litigation acumen. Not many of our clients at the time, going back years, knew that we had a transactional group. And we've really grown that practice to the point where a lot of our litigation clients that are, the Relateds, the Vornados of the world, those types and size of clients are now giving us transactional related work, which is great for us. I say we're on the map. We do deals all over the country now, which, not many clients still to this day know about.
Yeah.
But, we do joint venture agreements, we do preferred equity deals, we do leasing, we do buying and selling and refinancing, not just in New York, but all over the country. We just finished 4 deals in Dallas, Texas in the last 3 weeks. it's amazing how, we've grown and we've gone beyond what our original, stick to the knitting practice was, and have expanded that to great lengths.
Yeah, but that expansion is a natural one and not necessarily, it's just a little bit more fabric maybe.
I think, to your question of how do you get that work when a client tells you, I'm loyal to A, B, and C for each facet that you pose, I think the answer is I would never want to dissuade somebody from, breaking the trust and loyalty that they've had with somebody for a long time. I simply say, just give us a chance. Just give us one case, one deal, one transaction. Doesn't mean you're being disloyal or distrustful of your existing.
Yeah.
If you like what we do, you may consider giving us another one, and if not, then nothing has really changed.
Yeah.
So I think we've grown our firm that way because, look, we were a new firm when we started, and a lot of people use other firms, and I think, our results, our client responsiveness is a huge thing for clients. Clients come to us often because whoever they were using before is not responsive to them. And once they give you one case, you do a good job, they'll give you another one. Just a matter of time.
Yeah, I think the sampling is important. Skepticism is still abound and that kind of thing. And I agree that I'm not trying to take something away from someone, but give me the chance. And sometimes it works and sometimes it doesn't. But you never know, the other lawyer may be so busy that they may need you to come and step in.
Right.
Yeah. In transactions, we're kind of like in a different pool, so to speak. A lot of our competition are the larger firms. And, I like to think that our firm can do as well, if not better, when it comes to, dirt lawyering, buying, selling, leasing, and financing. We could do it a lot more economically and a lot more efficiently. And that's how we've grown that practice to really take from the larger firms and, bring them here and do that work, cost effectively.
Yeah.
And also those larger firms, they know how to do a transaction. Everything else we do, they have no clue what to do. There are times that the larger firms reach out to us to do some of the other things because they can't do it. So one of the benefits is not only it being more cost effective and as efficient, is that, again, we're a one-stop shop. You don't have to go elsewhere and have the coordination of multiple firms trying to touch one deal. It's just one place.
I think clients have a non-understanding of what it's like to have to deal with another firm. Not that it's bad, but having things internally where you can walk to somebody's office,
sure,
or call them or text them and converse with them, that makes a big deal, and that's going to show on the invoice, and it makes for a more seamless team versus having
100%.
Yeah, so
100%.
I think that's kind of lost on a lot of people for some reason because of that loyalty. And I'm not saying, again, the loyalty is fine, but you kind of have to understand the business behind it and make the right decision. And I want to touch upon one of the things that you said before, Jeff, which is these periods of time. We go with the what's happening, right? The financial crisis, which seems to happen every 2 or 3 years, or at least somebody saying that the sky is falling, and of course COVID, right? And you yourself, you were a trailblazer in that field in terms of tenants trying to get out of leases as a result, right? That was one of the things that you had worked on. I'm hoping I'm going down the right path. But in terms of the COVID-19 leasing work and your guidance to clients, where people said, you know what, we're not coming to the office. Why should we pay? We don't have any money. We had to fire a bunch of people. We're a restaurant. We can't have people in the restaurant. Whatever the case may be. And this is a question for you too. But in terms of you trailblazing that, what were those cases, and how did you kind of face that first time scene, which is, I'm sure, has happened to you throughout your career? And it's going to be the same question to you, is what was the state of leasing at that point?
I think during that period of time, we circled the wagons as a firm to make sure that our staff and employees and associates and partners were safe, and that we would still be here today. The world was coming to an end.
Or so it seemed, right?
So it seemed at the moment, and it always does in the moment. Courts were closed, so there was going to be no litigation. People weren't around, you know, trying to get in touch with people. So I think, so once we kind of got our arms around that, the next phase was, okay, what's important to our clients? What are we hearing from our clients? To the point you said, there was both residential and commercial. People aren't paying rent, understandably, for the most part. So how do we work together to try to restructure leases to defer rent, extend leases and make the arrears, on the back end of leases. We together creatively came up with ways to keep tenants there, get some flow of money to our clients, preserving the ability to recapture monies that may have been lost. It was for years a real problem. It was for clients because the courts were closed.
So you're trying to restructure these leases post fact to obviously make deals, because it's not something that was contemplated. Now obviously everybody has some kind of force majeure that includes language like this, which was
exactly.
Yeah, that's kind of like, I guess, turning to you, which is you guys are working hand in hand. There's a lot of litigation, and there's
a lot of litigation over the force majeure language that became central to either tenants trying to get out, and then there was a change in the guarantee law that came down from our wonderful state legislature. But that's a whole different topic. But Dan could address the drafting of those documents.
I think I just want to go back to what Jeff said before, which was, it's important to check and make sure the home front is good before you go out to the marketplace and deal with clients in that very, very difficult time. And I think Jeff and I are most proud of the fact that we didn't have any attorneys who left the firm. We didn't fire anybody. We really focused on making sure that people felt safe and that they were taken care of, because there was so much uncertainty, in the world. So that's something, we're really proud of. But as far as, tenants and landlords are human too. During that time.
Some people would disagree.
Believe it or not, they are.
Certainly the city council and the state legislature would disagree.
We'll get to that momentarily.
I was really surprised, in a good way, that a lot of our clients were very sympathetic to both the residential and commercial tenants. And, to Jeff's point, we came up with a really good form of a rent deferral agreement, that took into consideration how long we were going to give the tenants to pay their arrears, what happened if they didn't, extend the leases on the back end to kind of, make it a little bit more fair to the landlord. So, we tried to do a good job in balancing everybody's motives, and I think we did a great job during that period.
I think it was a tough period, and certainly something that's never happened, at least not for 100 years at least, and
hopefully won't happen again.
That's the hope, but who knows exactly what will transpire. Now I want to kind of turn briefly to something that's more up to date in terms of the things that are transpiring in New York, which almost may seem worse than COVID at this point. And we can talk to whatever lengths that you would like, and what's going on in the markets in general because of the effect of the new mayor. Psychologically, what he does to me, we don't know, right? So psychologically, what his win does, what the proposed bill for COPA does, whether it passes or not psychologically, because I'm having clients call me in panic, and there's not really, it's going to affect everyone.
It's only in certain zones, right?
I read through the thing, and we may have to edit this, but I thought it was mostly throughout the city with some minor exceptions where it's 3 units or more. For some reason, I was under the misimpression that it was just public land. So I didn't, it's basically anything that has 3 or more units.
Multifamily, everything.
Yeah, and the problem is that you have this waiting period, which is a big problem, right? If you're trying to not refinance, you're trying to pay off your loan, and you have to wait that period, and then I'm sure there'll be litigation with these not-for-profits saying you didn't accept my offer, it was better, although you don't have to accept it right now. I think it's going to be a problem, and right now it seems to be on the trend to passing. How that's possible, I don't know.
Yeah.
And other things.
Let me just rewind and then quickly 6 years. In 2019, when the HSTPA was passed, that was a watershed moment for property owners in the city. It completely changed the landscape. One, how to litigate, two, grounds to litigate, and three, how landlords, owners can increase rents and recover apartments. That changed, it created overcharge periods that never existed before. It eliminated the ability to increase rent. So that, and then I'll let Dan speak to the impact that had in the transactional field. But from litigation, it just opened up the floodgates of litigation that still get litigated today on that language. Fast, before we even get to the new mayor, you have a state legislature, city council, and you have the judicial system that is bordering on or as close to the line of progressive as there has ever been in the city of New York. And I put the courts in there because anybody who went to the ballot in the last election, there's only judges under the Democratic column. There are no Republican judges, whatever you want to characterize them to be. And judges are now interpreting laws as favorable as possible to tenants, because there's millions of voting tenants and there's very few voting owners. And then fast forward to what is being proposed, which is effectively, I think, going to create tons of litigation. Good for us.
Yeah.
I think it could have a stifling effect on people who are willing to buy and or sell. What do you think? Yeah,
I agree. I think it's, certainly the injection of Mayor Mandami and his win has created a lot of uncertainty. A lot of our clients are very concerned. They're concerned about rent freezes. They're concerned about more regulation. They're concerned about higher taxes. Those are all the things that, he campaigned on. And I guess the good news for the real estate community, and I'm not sure if it's good news, so to speak, but he can't do everything on his own. He needs the city council. He needs, the governor in some respects. So, the jury is still out and will be out. We're fairly new, in his administration. So, we'll see. But, this new COPA law is just, it's crazy. It's a chilling, basically, and a suppression of values in the city when it comes to, buildings of 3 or more units. And, to have a waiting period before you can actually go to market, it's going to have an untold, impact on the market and the values that we see. And to Jeff's point, they're already depressed from, the 2019 HSTPA.
Yeah.
This is only going to make things worse. And, I'll tell you that we've had many clients who have said to us, based on this, continual swing to the left, it's difficult to really be an owner in New York City, and a lot of our clients, not that they've left New York City entirely, but they've gone elsewhere. The cap rates are much better, investments are easier. You can evict somebody in a week, in Florida and Texas. These are things that really impact ownership and values in people, who do this for a living. So I'm nervous. I'm concerned about it, and I know our clients are as well.
If you just think about it, if you own a single family home or a condominium or co-op, imagine if someone said to you, look, before you sell it, you have to give somebody else the opportunity, whether it's 3 months, 6 months, 180 days, to negotiate first on what you think the fair market value is. They may not think it. And if you disagree, you then have to go to arbitration as to, I just want to move my family and get on with my life. Yeah. And so what's going to happen? There'll be plenty of people with cash to lowball a number, but then if you lowball a number, the affordable housing or charity groups are going to say, okay, I'll match that number. it's a nightmare. I do not see how that could be constitutional.
Yeah.
And it also attracts abuse too. Like, we talk about, from what I read, you have to be a quote certified buyer when it comes to, buying these types of properties. I can bet you that there will be people that will stretch the rules and try to become a quote unquote non-for-profit, or, whatever the qualifications are for you to get certified will be bent. And to me, that's, it's not a good thing any way you look.
Yeah, it's going to lead to abuse. It's going to lead to chilling effect. And I agree, it's going to lead to people just saying, we're out of here. We'll wait the 120 days and we'll just sell the thing and we'll leave and we'll go someplace where we're free to do what we want.
Right.
And that's a problem, I think, for us. And I don't think everybody's saying, well, the Madani effect is he's going to tax the rich are all going to move. Maybe, maybe not. But the point is that this is eventually going to come to fruition. Is there anything that you see right now currently, not speculation, not fear, something currently that is of effect of this environment, not specifically Madani or Copa, but this, what I would say, anti-owner, landlord, and developer as well mindset? And it's kind of unrelated, but why do you think that is? Why do you think that owners, developers are demonized? And I understand there is a bad class, but every profession has a bad class of people. Every job class has a group of people that are bad apples. But for some reason, owners and landlords and developers seem to get it more, particularly in New York City.
I think, to answer that question second, one of the things that's also going to be coming down the pike are ghost apartments, the tens of thousands of apartments that are sitting empty because owners have no financial incentive to fix them up. And I could see a future where owners are going to have to register apartments as empty, and regulation that will try to compel them to do something to put them back on the market.
Like a penalty, right?
Yeah, like tax them
or something. But landlords from the medieval times have always been the boogeyman, where you can go from medieval times to Europe to the 1800s here. You can see it in movies, in TV. The landlord is the bad character in every story because you have to pay him or her money to use their space. So I just think it's just everybody needs a boogeyman, and this socialist progressive movement needs a boogeyman. You could be a billionaire. You could be, we have a lot of clients who are just small property owners. They're just people who have they can't afford the carry as it is now, yet they are lumped in as the boogeyman. I just think it's been that way forever.
It's an unwarranted perception that landlords have endless amounts of money, that they live really wealthy, they have big yachts, they travel the world, and all they do is collect rent. That's not how it is, especially in New York City. They have to work. They have to fix up their properties. They have to take care of them. They have to make their tenants happy in order to get the rent paid.
And who's the worst landlord in the city of New York with the most violations?
The city of New York.
NYCHA, New York City Housing Authority. And if you listen and watch to every regulation that is passed, it always excludes city and state housing.
Yeah.
All the laws carve out the city from having to comply with the same requirements that non-city landlords have to comply with. That's
no
insane.
Accountability.
Insane.
Yeah. And like you said, they're some of the worst.
They are the worst.
Yeah. And then there's no protection there because of that exception.
Right.
Which doesn't seem right. Just kind of turning back to the 2019 rent laws, only because we don't have kind of any precedent for this effect that we're talking about right now. What did you learn from those lessons, whether it's guiding clients or actually litigating those issues? What things did you learn by diving into those things? And also, how did you catch up to speed on all of the this is brand new stuff, and I know what it's like to do brand new stuff because the zoning resolution was just amended, so you're just rushing to try to figure it out, making sure that you're reading it correctly, reading it, rereading it, and highlighting it a million times. It's like you're back in law school trying to learn stuff, and there's no precedent. So it's like you're learning it, and you're relying on your skills to read and reading comprehension, but at the same time, there's no precedent, so your reading might be not.
Yeah, I
exactly
think
right.
you're reading it. We have a depth of history, 30, 35 years of experience in the courts on these things. I think you're counseling clients. This is our best interpretation of what it says. We can't guarantee how it will be interpreted by the courts. It's likely to be interpreted in a way least favorable to you. So when you decide whether to buy it and you now have this risk, or you already own it, and how do you navigate fighting with a tenant on a particular issue, you have to counsel them with the uncertainty of uncertainty.
Yeah.
And let them make the decision. And it's only over time. And as we, get those decisions, interpreting it in one way or the other, we internally and very quickly through social media and email blasts are notifying clients in real time, here's a decision sustaining our interpretation. Here's a decision contrary to our interpretation. It's only a lower court, who knows what a higher court. So it's knowing the judges you're before, which we do, knowing what their inclinations are. So that also helps feed into should you settle or not. But that's what experience and honesty with clients gives our clients, which is real-time information to make decisions.
Yes, and I think having that real-time information is key, and the way that you are able to do that is because of the people that you have here and experience. And I completely agree, right? The law may be new, but reading the statute, understanding what it was before, what's turning to, why it is happening that way, you are in a better position to interpret it, obviously, than anyone, and I can completely understand that.
I think one thing, and Jeff could probably comment on it better, but I hear it all the time from clients, is why does it take so long for a judge to make a decision? Why does it take so long? I mean, most of the time, they're very straightforward cases. Either the tenant's in there beyond the term of its lease, or the tenant's not paying its rent. Why does it take a year for a judge to go ahead and decide that kind of case?
Do you have an answer?
That has to change. I'll tell you, we're at an extreme or approaching an extreme. That has to change because it's becoming very, very hurtful and prejudicial to our clients, and somebody has to do something about it, and it's important.
It never used to be that way pre-COVID. Even back when I first started in the 90s, early 2000s, you would, even if it was a bad decision, you would either get it from the bench or in short order. It slowly took longer and longer. COVID, obviously everything stopped, and coming out of COVID, the answer from the court system was, we don't have as many clerks, we don't have as many, judges are busy, all the requirements and restrictions, things have slowed down. They don't address that the volume has also been cut in half, so with volume being down, why is it still taking so long? I'm waiting for a decision for 15 months.
Wow.
I've written to a judge 6 times, it's coming, it's coming, it's coming. I've threatened the mandamus. I've written to the administrative judge, which is the judge of all judges. Just last Friday, we were told we would have it Monday. This is a non-payment holdover because the lease has expired and they owed $250,000. But we were told we'd have it Monday. As of the taping of this, we have yet to get it. And it's Wednesday.
What do they say? Delayed justice is no justice.
And honestly, they're just lazy. And I would say it to a judge. They're just lazy. They don't get on the bench till 9:30, quarter to 10. If you're lucky, maybe 10, and they close down by 4:30. Where else do you get it?
How's it? I mean, I agree. It's a problem, and dealing with agencies is also, although HPD is just completely underwater, and that's sort of the scenario we're under over there, juggling legacy programs, new programs, but it's a problem, and maybe judges don't have the same issue, but I think that idea of, and that goes back to COPA, right? If it takes this much time is money, and you are expending money and you're losing out. Every day your application isn't granted, every day you don't get a decision because you want to get on top of the execution or go to the next step and appeal it, and I think that's I think that's very, very problematic. Turning to the way that the two of you work together, which is there any transaction that you worked on, Dan, that then had to end up on your desk, or perhaps some advice that you had to give to clients pre-litigation that then ended up in some structured transaction that ended up at your desk? I'm just curious, like, that dynamic is an interesting one because you flow in and out of litigation and transactional, and they kind of...
Thank God I don't remember any lease clause I drafted that Jeff had to litigate.
That's great.
For me. Unless he remembers, but I don't recall. But I
remember a client.
Yeah, one client.
No, but it was we talked. I don't want to obviously use client names, but nothing I think where we talk all the time.
Yeah.
And the fact that something turns into litigation down the road doesn't mean that there was a problem with drafting or vice versa.
Yes.
But I think, as I said earlier,
I know very well that anybody who gets sued doesn't necessarily get sued for a reason.
Yeah, you do know that well. But as a former partner said, all it takes is a pencil and a piece of paper. You can start a lawsuit.
Right.
I think we've litigated leases that our firm has prepared. So there's constant interaction. And, Dan will come into my office, ask me my thoughts on something, and vice versa. If I'm in the middle of a litigation and it's a particular clause, I'll walk into Dan and ask him what does he think. I think the friction point between Dan and I, as a litigator, I find leases way too verbose and wordy. I read these clauses. And they are half a page, and they probably could be said in 3 sentences. So if I'm looking at clauses that Dan's negotiating on a lease, I tend to err on trying to make it cleaner and more succinct, because when you're trying to interpret a half a page clause that has periods, commas, semicolons, notwithstanding the above, that's a great example, notwithstanding the above. So, you put that in paragraph 47.
What about if it's below? It's notwithstanding the above and the below?
So people will say, notwithstanding the above, something will happen, or you'll get a waiver, right? But let's assume for the moment, when you're redrafting things all over the place, whatever was above is no longer above and it's below. And to your point, it doesn't cover what's, that follows. So, so the better language would be, notwithstanding anything contained in this agreement.
Yeah.
It's safer. So it's those kinds of things that I look at, and I'm sure Dan and his team look at as well, and looking at leases.
Yeah, especially when you're amending something and you forget that, and that could be, so you have to make sure that you're reading back. And I can't disagree with you that things are very verbose, but they're for a reason. They start out all fine, right? You're just kind of drafting something, and then somebody puts something else in, and you're like, well, I have to put something else in, and then it kind of gets out of hand. Yeah. What are the kind of the trends that you were seeing? So I work with a lot of developers, and so I'm not in the business of developing property, but just because I speak to so many brokers, developers, owners, lenders, I get a feel for it. And it's very odd how that happens, but I kind of know more about the stuff and the trends and what people are looking at than I should know as an attorney, but given the information that I have and the people that I talk to, I just have it. You just have to absorb it. And so both of you are deeply entrenched in these items, and you're even talking to clients that are thinking about starting a litigation, or getting a letter from an attorney who wants to start a litigation, and you're trying to resolve those disputes. So you really both have kind of insides without using specifics. What trends are you seeing that are interesting, or something you want to share with the audience?
I think the only, to the extent it could be a trend, or it could just be a coincidence, I think we have seen over the last year people trying to get out of contracts and fighting over deposits, and or having bought something and when they move in it's not what they said it would be or should be. I think that has increased over the last year. I can't think of anything new.
I'm seeing, the office market in New York is getting stronger. Despite the fact that companies, still allow, their workers and their employees to work from home, including ours. I'm seeing a lot of, people, rent space in New York. Like they say, there's no place like New York. The office market is certainly getting stronger. And I also could say that about, services. We have a vibrant hospitality practice. We're seeing restaurants, coming from other countries, wanting to be in New York City because this is the place where things happen. And, we have a very exciting, leasing practice when it comes to restaurants. And I'm seeing an onslaught of restaurants expanding in New York City and wanting to be here.
Yeah,
that's something.
Opportunity too, right?
Yeah.
And I guess, the other thing, I guess really it's been for years, but it is growing, is our 881 practice, negotiating the access agreements. Yeah. And again, the benefit of our firm is sometimes when the agreements the parties can't come together, you have to litigate. And if you don't use a firm that does and has the experience in litigating 881s, all you do is negotiate 881s, you're going to have to farm it out to another firm, whereas we do that here. So I think our 881 litigation has grown. Clearly our 881 negotiating and drafting of those agreements has grown. And even when you have those agreements, it results in litigation in the event parties breach those agreements.
Yeah. And that's a testament, Jeff, to, the development in New York City. I mean, you see it every day, David. The fact that we have clients that are looking to build in our building and need to strike an agreement with the neighbor because they need to put, netting above their roof or terrace. These are things that continue to happen. New York is not dying. It's continuing to evolve, and development is stronger than ever, I see. And that's because, people want to be here. And like Jeff said, we have, over 100 of those access agreements where either we're being asked to provide access or a developer client of ours needs access because it wants to build something next door.
And also just the aging of the city that requires scaffolding to be put up and pointing and brickwork to be done triggers all of those 880, all of that 881 work. And the one thing we haven't discussed in the hour that we've been together is our huge co-op condo practice, where a lot of those 881 agreements, again, on both sides, emanate from as well. So, we were able to expand that practice as we discussed earlier, and now these buildings either need access or are being asked to provide access. So that also is a huge part of our practice and growing.
We represent, just to tout it for a second, 300 to 400 boards where we're doing governance, we're attending board meetings, we're providing advice when it comes to issues, dog bites,
sales,
noise,
transfers,
smells, you name it. Our co-op and condo department is addressing those issues on a daily basis.
Yeah, those are challenging issues.
Yeah, how to conduct a vote, how to conduct an election. Those types of things come up every single day, and we're representing 300 to 400 boards that need that advice and counsel, and we're there for them.
Yeah, particularly because of all the law changes and all the regulations in terms of environmental and things like that. Mm-hmm. But just going back, and I'm going to wrap it up soon, which is the 881, because I do a lot of license agreements as well, not so much in the co-op capacity for local laws, but because of development, and it just naturally progression. I'm dealing with developers, and so it's a natural progression to do those things. What are generally the strife? What is generally the arguments, and do those actually go to a decision, or does the judge say, figure it out, I'm not deciding this stupidity, I want you to... Because generally, most of the time, from what I've seen, it's a lot of nitpicking and things that don't necessarily matter, but that's just my experience. What has has been the bottleneck that you've noticed?
Before Jeff answers that from a litigation perspective, I see, it's people, first of all, it's seasonal. People want to get their work done, right? In the spring. So things are everyone's rushing now to get these agreements done. And then, they want to be able to do as much work as they can over the winter, but a lot of times they're unable to do it. So, that's one thing. And secondly, it's important that, people understand that not everyone's on the same timeline. That's where the big strife occurs. You have the person who wants to build or has to do the local law 11 work or has to do some type of work that's impacting, their neighbor, and the neighbor's like, you're bothering me.
Yeah.
I don't want to do this. This is not something that I'm going to benefit from. Although a lot of times we'll negotiate a fee on behalf of the adjacent property owner. It comes down to the timing. They're just so different and variant that it causes conflict.
Yeah, I've seen that.
I was going to say it's timing, but maybe when it gets on my plate, it's more than the timing.
Yeah.
But it's the license fees. People who are giving up the access want more than the people who are asking for the access, and it's just a made-up number, typically. And the lawyer who is representing the person who's giving up access wants their fees paid. So
that's a big one.
What's the reasonableness of those fees? And lawyers tend to, they err on the side of asking for more than the reasonableness of their fees might actually be.
What's reasonable?
And then the same on the license fee. I just, with my partners or cats, representing a condominium who needed access to an adjoining building where the adjoining building owner had 5,000 square foot rooftop terrace with 4-way exposure, so to speak, plus a 5,000 square foot apartment, and we needed access for only 20% of the exterior space, which was north facing, and the unit owner had unobstructed views east over the Museum of Natural History, unobstructed views south and west where they had their hot tubs and barbecues, and the space that we wanted was about 1,000 square feet, which is 6 feet wide, probably ran 100 feet, and it faced a brick wall that they never used. never, ever used.
But it became really important to them.
They wanted a $15,000 license fee.
I mean, there's a reason they can afford that apartment, right?
Yeah. And
Titan of industry.
Yeah. So they wanted a $15,000 fee, litigated. Access was agreed upon, all the terms. It was now we were fighting over the fee.
Just the fee.
Ultimately, we won. The court found that they didn't sustain their claim for $15,000 fee, but based upon the cases, gave them a $4,500 fee. The lawyer, although his case was dismissed, is now submitting legal bills of in excess of $300,000.
Wow. Are those reasonable?
In the lawyer's mind, it is. I don't think a court, one, they didn't win, so I don't know how you get legal fees, and two, I don't think a court will. They spent 3x of what we spent.
What is it? So I'm almost asking for my own knowledge. What is the reasonable? What is the reasonableness that the court determines? How do you? Is there have to be a number? Well, I'm missing this, and this has cost this much, and I would have rented this piece out, and I would have gotten this much money. And
well,
so
I think part of the analysis for the court is what did you get by choosing to litigate, other than running up your fees? Is it what you achieved valuable compared to what we were offering?
Yeah.
We offered them $4,500. They ended up getting $4,500. Coincidence? I don't think so.
No.
But, and there are cases that say that courts should be wary of these cases where it's a fees-oriented litigation, not truly a license fee. So we're hoping the court will find that they get nothing.
Have you ever been able to dissuade somebody from proceeding with a litigation like that by basically giving them the riot act and letting them know that this is how courts have decided, or that just deaf ears?
Adversaries don't take to what their adversary tells them is what it is.
Yeah. I knew that was going to be the answer, because if not, I would have been very successful in
that would be great.
encountering lots of adversaries.
Oh, Jeff Goldman said that's unreasonable. I guess I'm going to ask for something less.
Jeff Goldman, right?
Yeah,
So I mean, that's exactly what I expected.
Yeah.
And one of the things that I wanted to wrap up on is, in terms of your careers, which have obviously been very expansive, and all this knowledge and wisdom that you have accumulated in many facets of real estate. What are the things that you think or would want people to really know you for, that you're most proud of, in terms of whether it's a decision, or even if something not in the public eye, some sort of resolution that you came to? It doesn't even have to be one thing, but if there's something that you can think of that's like, this is a standout. This is like one of the first things that comes to my mind. I did this XY, 20 years ago, whatever that might be. And it's kind of like an open floor. You can talk about it. But I would love to hear, like, what is it, kind of like almost your legacy, what you would want to be known as if a book or a movie was made about you? It's a very existential question, right?
There is no greater feeling than winning a jury trial, but to answer your question, as I approach the end of my career over the next many years, I think the training that I've given to attorneys that I've worked with over the years, that they are better attorneys, maybe better people, but certainly better attorneys. And I know, without listing the names of people who have been here and who have left and who are still here, that their careers were impacted by working with me, getting to know me, training with me, observing what I do, and it has left them with, their careers being better. And what I tell everybody who I hire, if you treat this like a job, you'll fail. If you treat it like a profession, you'll succeed. And so hopefully that's the impression I've given to attorneys. And that to me is more important than any win or great case that I've ever had.
It's almost like you practiced that. That was amazing.
No, I really haven't, but I've certainly thought about it.
Let me tell you what, that was not what I expected, and precisely the answer that I love to get, because that was genuine, right? Like I'm goading you to say like this big win, I won this trial, and you say something so great that I would not have expected that, and I appreciate that. That's I think it's genuine, and I think it's a listen. That legacy will go on, and it will live in other people for generations.
Hopefully.
Yeah, for me, it's I'm like second generation. Jeff and several of his partners started the firm almost 40 years ago. I was one of the first associates, and I've been at this firm ever since. I've never gone anywhere else. I've never been anywhere else. So I'm approaching 37 years, and the firm, probably for the first 20 years was probably stagnant in its growth. And what I'm most proud of is with Jeff, working together, as co-managing partners, we've grown this place to be really powerful, profitable, and most importantly, a great place to work.
Yeah.
I mean, if you ask Derek, our COO, one of the greatest statistics that he'll share with you is the average tenure of an attorney at our firm is 12 years. That says a lot about our firm and what it's like to work here, how rewarding it is. We really care about people. We understand that people have families, and on the other hand, we do expect good work, and we expect people to work hard. So that's the legacy that I'm proud of.
And one of the stories, not that I will embarrass Dan, but one of the stories I remember.
No, you should embarrass. I mean, that's why we're here.
Just to tell you the kind of person that Dan is. When he was at our firm and he wanted to be equity partner, and we told him, we may have told him no twice, but was it twice?
Yeah.
And
no, you changed the tenure once. You said you got to wait another year.
Yeah. And I remember, like it was yesterday, in the meeting with Dan, and he could have handled it in many ways, and the way he handled it was professionally, and I'm just going to work as hard, if not harder, to make it so that you can't ever say no. And that's what he did. Yeah. And that's who he is. And that's how we built the firm, and that's how he, co-heads a department and co-manages the firm with that kind of attitude.
No, it's great. I mean, it's exactly how I want my wife, right? Because I don't take no for an answer. I'm going to persist. You said no, I'm just going to work harder to make myself more attractive. Yeah.
Well, you're quite attractive, David.
I have you on video now saying that, by the way. So it's perfect. Now I want to give you guys both first of all, amazing guests. I've never interviewed two people at the same time, but very natural. I hope you felt the same way. And to me, this inaugural episode means a lot. I'm really excited to be back on a microphone and doing this, and I really do enjoy this. There's a lot of work behind it, but I enjoyed it. You two were amazing. I could probably talk to you for another 2 hours, and I won't because there is the billable hour.
And we also have clients who are looking for us, and we like to get back to them quickly.
They'll know eventually what we're doing. But I wanted to give you both an opportunity to say something that maybe you wanted to say, didn't have an opportunity. If so, it doesn't have to be. Share anything that maybe I didn't ask you that you think you want to say. And if not, that's okay. The two of you are accomplished in this field.
I think we hit it.
I think we, over the last hour and 22 minutes,
Yeah.
I think we're pretty good.
We hit it. Listen, got to make sure.
Right.
So everybody, thank you very much for staying in tune, and we'll be back with more episodes. And this is Ground Rules. We love this firm, and we thank you so much, Jeff and Dan, for joining us and taking the time.
Thanks, David.
Thank you for having us.
All right. Bye-bye.